Welcome back to The Deep Dive. Our mission here, as always, is simple. We take complex, expert source material, we break it down, and we give you, the learner, the foundational knowledge you need to be instantly well-informed.
And today we are really kicking off something big.
We really are. We're starting a major foundational series dedicated to the absolute bedrock of litigation in Ethiopia.
Civil
Real procedure.
And this is, well, it's a monumental task, but it's an absolutely necessary one.
Yeah.
Especially for our audience of, third-year law students.
Right.
Substantive law, the part that defines all the rights and duties and so on, that's only half the picture. Civil procedure, well, it's the engine. It's the body of rules that determines whether those rights are delivered or delayed or sometimes just outright denied.
So without it, you have nothing.
Without procedural mastery, substantive law remains, as we often say, just a pretense.
Absolutely. So our deep dive today tackles Chapter 1, an introduction to civil procedure. We're going to unpack the definitions, the crucial distinctions between different types of law, the ultimate goals of civil justice, and maybe most importantly, the fundamental principles that guarantee due process inside the Ethiopian system.
And we'll be citing provisions, talking about specific proclamations, and even getting into some pretty controversial cassation decisions.
We will. But before we jump into all that, I really want to make a very special and sincere acknowledgement.
Yes.
The incredibly detailed, rigorous, and frankly comprehensive material that forms the basis of this entire discussion, and really this whole series, was prepared by Mr. Abdurrahman Said. He's a respected lecturer and a practicing lawyer.
And his expertise is really what allows us to go this deep, to provide this specific level of analysis.
Exactly. We are just so thankful for his preparation. So, okay, let's do it. Let's unpack this fundamental body of law that brings life to all substantive rights. And let's start with a question that seems simple, but really isn't. What is civil procedure?
It seems obvious, doesn't it? You hear civil, you think private persons. You hear procedure, you think method.
Yeah, straightforward.
But the legal reality, it lacks a single clean definition. Black's Law Dictionary, which is, a global standard, gives a pretty basic one.
What's that?
It says it's the body of law governing the methods and practices used in civil litigation.
Okay, that seems like a solid starting point. So if that's the definition, why does our source material suggest that it's not really enough, especially in the Ethiopian context?
Because of the profound difficulty in neatly separating legal rules into two neat little boxes, you can't always say this is purely procedural and this is purely substantive.
The lines get blurred.
They blur constantly.
Yeah.
So we need a way to understand the law when the rule makers themselves put procedural ideas inside substantive codes and the other way around. So the most productive approach for you, the law student, and the approach we're taking today is to understand civil procedure teleologically.
Okay, hold on. Let's unpack that term. What do we mean when we say understanding it teleologically?
Good question. Teleology is all about purpose or, final causes. So we don't define civil procedure just by what it is, the rules on a page, but by what it does.
And what it's trying to achieve.
Exactly, what its ultimate goals are. By understanding its purpose and comparing it to other laws, we get a much, much clearer picture of its scope and its importance in litigation than any dictionary definition can really give us. And this leads us straight into the great dichotomy.
Let's lay out those two pillars of law that every student absolutely has to master. So first, we've got substantive law.
Right.
This is the law that defines rights, duties, privileges, all the liabilities. It regulates how people relate to each other in the ordinary course of life. You're thinking civil code, penal code, commercial code.
And then, second, you have the procedural law. This is the method. It provides the means for actually enforcing the rights that the substantive law creates.
It tells you how.
It tells you how a claim is prepared, how it's presented, how it's adjudicated before the court. And critically, it governs the relationship not between the parties out in the world, but between the litigants and the court itself. The Civil Procedure Code, the Criminal Procedure Code, those are the prime examples.
Now, there's a claim you often hear in academic circles that procedural law is just adjective law. The argument being that it has no independent standing, that it's secondary, and it only exists to serve the ends of substantive law. It's often seen as, less noble or less important than the big substantive codes. Is that a fair way to look at it?
It's a position that, well, it has to be heavily qualified, and I'd argue ultimately it has to be largely rebutted.
Okay.
While procedure is definitely a means to enforce substantive rights, it also serves an independent and, I'd say, vital end of its own procedural justice.
And that includes what? Fairness?
It includes securing fairness, yes, but also efficiency and the legitimacy of the entire adjudication process.
So, if the lawmakers got the procedure wrong, you could have the most perfectly defined substantive right in the world. Let's say the right to compensation for a breach of contract. But if the procedure for claiming it is opaque or corrupt or just doesn't exist,
That right is completely worthless.
it's nothing.
Exactly. The enforcement mechanism is what gives the right life. Without the Civil Procedure Code, substantive rights are just lines of text on paper. That is the core of the teleological justification we mentioned.
Prescription without application is nothing but pretense.
That's the phrase. The significance is massive. Procedural law prevents self-help, it prevents vigilantism, it gives people a formal, principled way to resolve conflict, it provides access to remedies, it ensures a balance of fairness and efficiency, and it gives judicial outcomes certainty and legitimacy.
I think we need to really emphasize that last point. It's not just about getting the right answer at the end of the day, it's about the process itself. I've often heard that today procedural irregularities can decide a case just as much as the substantive merits can.
That is the modern reality of law. A meticulously researched substantive defense can be completely lost on a technical procedurality.
Like what?
A failure to submit a document on time, improper notice to the other party, an error in the form of the pleading. This is why mastering procedure is just non-negotiable for any lawyer.
And this is where the distinction becomes so indispensable, especially for you, the third-year student listening to this. Because if the line between substantive and procedural is so vital, but also so blurred, we have to know why we're even drawing that line and how.
The why really centers on one key concept: retroactivity.
Okay.
Substantive laws are, as a rule, non-retroactive. They generally don't affect facts or events that happened before the law came into force.
No.
This is just a bedrock principle of legal stability.
You can't change the rules of the game after it's been played.
Exactly. But procedural rules, because they're seen as just governing the method of the trial, they're commonly deemed to be operative from the day they come into effect for all pending and future cases.
So if a new rule affects how a suit is tried, it applies right away, even if the thing that started the lawsuit happened under the old law. But if the rule affects the existence or the scope of the right itself, it doesn't apply backwards.
Precisely. And we see this principle governing the application of the code itself. It's confirmed right there in Article 1 of the Civil Procedure Code, which states that the code governs all civil proceedings from its date of effect.
Now let's get into those specific Ethiopian examples where this blurring happens. The source material highlights Article 1856 of the Civil Code. Now, on its face, this seems highly substantive. It's defining limitation periods.
Yeah.
Where's the procedural function?
Okay, so Article 1856(2) says that a period of limitation doesn't affect the right itself, but it just makes the obligation unenforceable by judicial action once that period expires. So it's a rule of prescription.
Right.
But here's the kicker. The court cannot take official notice of that limitation period unless it is specifically and formally pleaded by the party who's relying on it. That act, the requirement for a party to plead the defense, is profoundly procedural.
That's a perfect example. So if the defense isn't raised in the right way, that substantive limitation period effectively doesn't exist for that specific case.
And we see a similar kind of overlap with Article 1845 of the Civil Code. This article, it prescribes the circumstances when a contractual right expires, which is substantive. But by doing that, it's also determining the maximum time limit for filing a lawsuit based on that right.
Which is procedural.
Which is the procedural aspect.
Yeah.
The law is designed for unity, but it's the function of the specific rule that dictates its character, especially when we're talking about retroactivity and judicial intervention.
So, given this critical need to distinguish, we have to rely on the 3 yardsticks that the source material gives us. Let's break those down.
Okay, first, the most tangible one, the material source or the document. This is the simplest test. Where is the rule located? Substantive rules are typically in the civil, commercial, or penal codes. Procedural rules are in the Civil Procedure Code, the Criminal Procedure Code, and related laws like the Federal Court's Proclamation, number 1234/2013.
But, as we just established, that yardstick is inconclusive because the Civil Code is full of procedural rules. So we move to the second one, the objective served, the teleological purpose.
Right. Substantive law has a preventative objective. It tries to regulate conduct outside the court to avoid disputes. It defines the right way to do business or to have social relations.
And procedural law.
Procedural law has a remedial objective. It steps in when a conflict is already happening. Its ultimate purpose is to resolve that dispute fairly and efficiently. That goal, to secure the just, speedy, and inexpensive disposition of civil cases, that's paramount. It governs how you interpret every single rule in the CPC.
And finally, the third yardstick, which I find is the most vivid one. The functional sphere of application. Law at rest versus law in motion.
That's the metaphor that really sticks, isn't it? Substantive rules govern general conduct outside the courtroom. They are the law at rest. They define the static state of rights.
Like your right to own property.
Exactly. But procedural rules, in contrast, they govern the dynamic litigation process inside the courtroom. They regulate the active engagement between the litigants and the court about the proceedings. They are the law in motion. The Civil Code defines your right to ownership. That's law at rest. But the CPC defines how you file an injunction to stop someone from trespassing. That's law in motion.
That synthesis really confirms why procedure is so far from being secondary. It's the dynamic key that unlocks the static rights.
It is.
Okay. Moving on from the definitions, let's widen the lens a bit and look at the broader goals that the civil justice system is trying to achieve, both globally and right here in Ethiopia. The sources highlight a recognized duality.
Yes. On the most immediate level, the goal is, of course, the resolution of individual disputes. This is the core task. Settling the conflict between the plaintiff and the defendant efficiently and fairly.
But there's a second goal.
Simultaneously, the system has to achieve a second goal: the implementation of social goals, functions, and policies.
And this is where things like politics and social context start to bleed into the courtroom, right? How a society balances those two goals really defines its justice system.
Oh, absolutely. Consider the huge differences. If you look at the U.S. legal system, the civil justice system is often used for the private enforcement of public law rights. You see class action lawsuits enforcing environmental policies, for example.
The goal there is bigger than just the two parties.
The goal is behavior modification on a grand scale. It's making policy through litigation. Conversely, if a system, as some might argue happens in more traditional African contexts, prioritizes social harmony and reconciliation, that system might actively discourage litigation. It might push for non-adversarial settlements, even if that compromises the strict enforcement of an individual's rights.
So the process itself is a tool for social engineering.
Precisely. The social goals really boil down to a few key things: conflict resolution, which is providing that alternative to vengeance or self-help; behavior modification, which is imposing a cost now to change future conduct; and in common law systems especially, rulemaking, where judicial decisions set precedents that guide everyone's future conduct.
And all of these have to be served through the specific rules of civil procedure, which, as the source emphasizes, aim to secure those three non-negotiables: a just, speedy, and inexpensive disposition of cases.
That triad represents the perfect ideal. Justice has to be impartial and fair. It has to be speedy, because we all know the saying, justice delayed is justice denied.
But not too speedy.
Exactly, because justice rushed is justice crushed. A reasonable contextual balance always has to be sought.
And we noted earlier that the responsibility for achieving this balance rests on both the court and the parties involved. How does the idea of an inexpensive disposition relate to judicial error?
It forces a kind of cost analysis. A system has to strive to minimize the total cost. And that total cost is the sum of two different types of cost.
Okay.
One, the cost of actually operating the procedural system itself. Judicial salaries, court overhead, filing fees, lawyer fees. And two, the potentially devastating cost of erroneous judicial decisions.
Because a quick, cheap system that produces the wrong outcomes is incredibly expensive to society in the long run.
Prohibitively expensive. It destroys public faith and it destroys legal certainty.
This distinction between outcome justice, which is getting the right result, and procedural justice, just following a fair method, seems critical here.
It's absolutely critical. Procedural justice is not just instrumental. It has inherent, significant process values of its own. Even if a party loses a case, if they feel they were heard, that they were respected, and that they were judged by a neutral system, the legitimacy of the outcome and of the court itself is preserved.
That's the intrinsic value of procedural fairness.
It is. If, however, the procedures themselves become convoluted and lead to massive costs and delays, they stop being a means to justice and they become the very problem they are supposed to solve.
This brings us to some of the harsh realities that are cited in the source material about the practical implementation of the Ethiopian Civil Procedure Code. The dissatisfaction seems to be pretty widespread.
The critique is quite blunt. The frustration is often summarized by that very harsh popular observation you hear.
Which is,
It is better to be sued and stand as a defendant in our courts than claiming one's right through them as a plaintiff.
wow, that's a damning statement.
It suggests that the process of actively seeking justice is so tiresome and costly and lengthy that it's actually preferable just to defend against a claim.
So what are the specific procedural pain points that generate this kind of widespread distress?
The critique centers on complexity, a lack of transparency, uncertainty, and really inconsistent application. For students, the practical examples of malpractice are critical. We see what are called prolix judgments.
Prolix.
Judgments that are so excessively verbose and rambling that they are torture for both the person writing them and the person reading them. They just obscure the central issues. We also see really tiresome pleading practices that unnecessarily complicate simple matters.
And what about case management? Does the system fail to distinguish between simple cases and complex ones?
Absolutely. That's one of the greatest drains on resources. The practice of treating cases that require summary or accelerated procedures, matters that can be resolved quickly, as if they require the full, burdensome, ordinary procedure.
That just wastes everyone's time.
It wastes judicial resources and it prolongs justice unnecessarily.
And the single biggest enemy of speedy justice is often found in how hearing schedules are managed.
That's the critical irregularity. The lack of a sufficiently defined adjournment policy, or even worse, the weak, inconsistent, or abused implementation of the existing adjournment procedures. A lack of judicial firmness in controlling delays means cases can drag on for years, often for very minor reasons.
To really understand the gravity of this conflict between the strict rule of law and the spirit of justice, we have to talk about the controversial cassation decision that's cited in the source material. This is an essential point for law students to really chew on.
This is the definitive ethical and legal dilemma. The case involves a succession matter, a dispute over inheritance that had been fully litigated for 8 years through multiple lower courts.
8 years.
8 years. And the Supreme Court, in its cassation jurisdiction, ultimately quashed the entire proceedings in order to complete retrial.
And the sole reason for quashing it was a lack of material jurisdiction. After 8 years, the entire process was just invalidated. The citation is PNWF 590885P12.
That is the specific reference. Now, the order, if you view it through the lens of pure procedural orthodoxy, is correct. Jurisdiction is fundamental. If a court lacks the material jurisdiction to hear a case from the very beginning, any judgment it renders is arguably void ab initio.
Void from the start.
Right. And that defect can be raised at any stage, even after 8 years of trial, typically under provisions like Article 323(2) of the CPC, which allows challenges to jurisdiction on appeal.
But the moment you order an 8-year case to be retried from scratch, you have delivered justice crushed. The expense, the time, the emotional toll, it just outweighs the technical purity of the rule.
This highlights the core tension. Do we prioritize the principle of jurisdictional purity, or do we prioritize the public interest in finality, in certainty, and in judicial economy?
So what's the argument for the court's decision?
Those who defend the Supreme Court's action argue that judicial error specifically, allowing a court without material jurisdiction to proceed, cannot be legitimized, even under the guise of dispensing justice, because the court itself must be established by law.
They're prioritizing the structural integrity of the judiciary over the individual litigant's right to a timely resolution.
Precisely. But the critics argue that that kind of adherence defeats the very purpose and spirit of the law. After 8 years, the public interest in bringing the matter to a final close should outweigh the technical defect, especially since the jurisdictional matter could have, and frankly should have, been spotted much, much earlier.
So the takeaway for the law student listening...
The takeaway for you is that while adherence to the letter of the law is critical, you must always interpret and apply those rules with the teleological purpose, the spirit of justice in mind. Procedure has to serve justice, not destroy it through overzealous technicality.
Let's transition now to a necessary foundational comparison. The difference between civil procedure and criminal procedure. The classification is based on purpose, ultimate objectives, the nature of the legal interests affected, and most visibly, the parties involved.
Right. The fundamental dividing line is the nature of the wrong. Private wrongs, or what we call civil injuries, are breaches of private rights that affect specific individual interests. They're redressed mainly through reparation.
Usually.
Usually. Public wrongs, or crimes on the other hand, violate public interests. They're an offense against the community, and they entail penal sanctions that are designed for deterrence and punishment.
Let's look at the key differences, starting with who actually starts the action.
In civil procedure, the action is initiated by a private individual, the plaintiff, who is claiming redress from the defendant. The focus is private enforcement of private rights.
And in criminal.
In criminal procedure, the case is almost always initiated by the state, the public prosecutor, against the suspect or defendant. And that reflects the idea that the community itself has been wronged.
With the exception of offenses upon complaint.
Correct. For certain minor offenses, the individual victim might initiate the complaint process, but once the prosecution takes over, the action remains a penal prosecution. It's focused on punishment, not just compensation.
Next, the purpose and relief sought. Civil relief is primarily compensatory, as you said.
Yes, the primary relief sought is monetary. Damages, specific performance, restitution, or injunctions. Critically, there is no threat to the defendant's personal liberty or life in a civil case. They might lose money or property, but they won't lose their freedom.
Criminal procedure is the complete opposite.
The state initiates the criminal case to secure obedience to its laws by inflicting punishment or other measures. The outcome involves conviction and penal liability, which means the punishment can include deprivation of liberty, capital punishment, or a fine that's paid to the state.
The goal is totally different.
The goal is to punish, deter, and protect public order, not to compensate the victim, although restitution orders are becoming more common.
And the crucial distinction that the source material missed in its initial comparison, which our students absolutely have to know, is the standard of proof. The purpose dictates the level of certainty required.
Oh, absolutely. This is critical, because criminal cases carry the risk of losing life or liberty. The standard of proof is extremely high. The prosecution must prove the guilt of the accused beyond a reasonable doubt. The possibility of error has to be minimized.
Whereas in civil cases,
In civil procedure, where the stakes are primarily monetary, the standard is the preponderance of the evidence. This just means the claim must be proven as more likely than not. Call it 51% certainty. This difference reflects the state's very different objectives in each case.
and finally, let's contrast the alternative dispute settling mechanisms, or ADR.
Civil cases are inherently negotiable. The parties can use mediation, arbitration, or they can simply settle the case and withdraw it at any time, even while it's pending in court. Party autonomy is king.
But not in criminal cases.
In criminal cases, that autonomy is largely absent. The matter generally lies exclusively under the power of the prosecution office. Unless it's one of those offenses upon complaint, the state has the public interest mandate to prosecute. The victim and the offender can't just negotiate the crime away.
Okay, let's move now to the foundation of the entire system. The fundamental procedural principles. These aren't just optional extras, are they? They embody the entire notion of fair play, or due process.
They do. And failure to adhere to them fundamentally vitiates or invalidates any court decision.
And these principles are drawn from international standards.
Yes, were derived from universal standards like those found in the ICCPR Article 14.1, which guarantees the right to a fair and public hearing by a competent, independent, and impartial tribunal established by law. Our source distills these into 4 core requirements for the Ethiopian legal framework.
Let's start with the cornerstone, the fair hearing of a suit.
A fair hearing requires 3 sub-elements. First, the neutrality of the presiding judge. This means the judge has to be free from personal or subjective bias, no connection to the parties, and also free from subject matter or objective bias. So, no fixed personal view or interest in the outcome of the specific legal issue. Second, the right to be heard. This is the ancient maxim, audi alteram partem.
And for our listener, audi alteram partem means literally hear the other side.
Correct. It means notice must be given, and that party has to receive an adequate, reasonable, and effective opportunity to explain their position. And the key word there is effective. A mere token opportunity that doesn't allow for proper preparation or response actually violates the principle. The maxim is simple. Nobody should be condemned unheard.
And the third element is equality of treatment. This seems complex, going beyond just giving equal time in the courtroom.
It breaks down into 3 detailed pillars that ensure the parties are treated equally, regardless of their social or economic standing. First is equipage equality, or equality in preparation. This requires guaranteeing that a litigant has the same preparatory resources, legal aid, time to search for evidence, the ability to hire a lawyer as their opponent. It ensures fairness, irrespective of income. Second is rule equality. This ensures that similar issues are resolved through similar legal rules. The same rules of procedure and evidence have to apply equally to the plaintiff and the defendant. And third is outcome equality. This is the demand that like cases, which present similar factual grounds or legal circumstances, should yield similar outcomes. It promotes consistency and predictability.
The source also gave us that excellent alternative framework for thinking about fairness, linking it to voice, neutrality, respect, and trust.
And these principles really define the goal of procedural design. Voice is the chance to present your side. Neutrality is the perceived lack of bias. Respect is the system signaling that participants are valued regardless of their status. And trust is the outcome. The system is seen as being committed to its public mission.
Moving to the second principle, public hearing of a suit. This is guaranteed constitutionally by Article 21 of the FDRE Constitution. Why is public access so vital?
The purpose is transparency and legitimacy. As the maxim goes, justice must not only be done, but must also be seen being done. Open courtrooms ensure that the public can scrutinize judicial activities, securing the acceptability and reliability of the judiciary. If justice is done behind closed doors, public trust erodes very, very quickly.
With the exception, of course, of cases that are considered in camera.
That's right. In camera literally means in chambers or in private. These exceptions are very narrowly defined. They're reserved for situations where morality, public order, or national security would be unduly jeopardized by open proceedings. Think sensitive testimony from minors or maybe classified information.
The third fundamental principle is a non-negotiable independence of the judiciary and accountability of the judges.
Independence is a cardinal element of the rule of law, and it has two facets. First, institutional independence. This relates to the separation of powers. The court system has to be protected from executive or legislative encroachment. This is secured through the Constitution and proclamations, ensuring the judiciary manages its own budget and internal administrative affairs without external pressure.
And the second facet is personal independence.
This is the individual judge's impartiality. It's their ability to decide solely by the law, without fear of reprisal or hope of reward, regardless of who the parties are. And this is protected by rules governing secure tenure, financial security, and their appointment procedures.
But independence can't be absolute. The source rightly stresses the necessary compromise with accountability. Independence is not a license for irresponsibility.
No, absolutely not. An unaccountable judge leaves to the rule of the judges, where arbitrariness can reign supreme. Accountability requires workable normative measures, transparency, the readiness of judges to accept criticism, and providing litigants with reasonably adequate appellate opportunities. The system has to strike a reasonable compromise so that judges are both free from undue influence and responsible for their decisions.
And finally, the fourth principle, establishment of courts by law.
This ensures legitimacy. The hierarchy, the structures, the jurisdiction of courts must be explicitly constituted by law. Judicial power must vest principally and solely in regular courts that are established by a constitutional or legislative act. This prevents the executive or any other body from just setting up arbitrary temporary tribunals that bypass the established rules of procedure.
We do see exceptions in Ethiopia, though, like quasi-judicial administrative tribunals.
Yes, bodies like the Labor Relations Board or the Tax Appeal Commission. They are constituted by law, and they're entrusted with delegated judicial power. However, the source wisely flags the ambiguity that surrounds the Kabyle social courts in this context. Their precise constitutional and procedural legitimacy remains imprecise and is a focal point of ongoing legal debate about the proper vesting of judicial power.
So, having laid that foundation of general due process, let's get very specific and look at the structural rules that govern CP adjudication in Ethiopia, citing the articles from the Civil Procedure Code itself.
Right, these 5 principles really structure how litigation works in practice in Ethiopia. First is the principle of bilateral hearing. You'll find this in articles like 78, 223, 234, and 157. This is the audit ultram partem we just talked about, but operationalized. It guarantees an equal opportunity for both parties to present their evidence, to respond to claims, and to participate actively at every stage of the hearing.
Second, the principle of party presentation or control from Article 182. This is where that adversarial nature really shows itself.
Correct. Article 182 is crucial here. It places the primary burden of alleging facts and producing evidence squarely on the parties, not on the judge. The judge is an umpire.
What does that mean in practice?
It means the judge cannot typically conduct a sua sponte investigation, That's an investigation done on the court's own motion or go beyond the facts that are alleged by the parties. This feature really restricts the judge's role and is a clear adversarial element. Third is the principle of unity. You see this in articles like 82, 90, and 329. This principle fights against the fragmentation of disputes.
So we're aiming for efficiency by forcing everything to be dealt with all at once.
Precisely. Civil suits should be conducted and decided in a single, comprehensive proceeding. This discourages strategic sequential litigation, where parties might hold back claims or evidence to use later. The code obliges parties to raise all relevant matters in their initial pleadings, it requires specificity in their denials, and it severely limits the introduction of new facts or arguments later on, especially on appeal. Fourth is the principle of formal proof, reflected in articles like 205, 87, 83, and 84. This is a particularly rigid feature of our code.
What does formal proof require from the judge?
It requires that proof must comply strictly with legally prescribed evidentiary forms. Documents, witnesses, sometimes an oath, or an inspection. The judge cannot substitute their own personal, rational conviction, their gut feeling about what happened, for the legally required proof. They are bound by the law's hierarchy and requirements for evidence, and only evidence expressly allowed by law is admissible. This contrasts starkly with systems where the judge is just seeking the most convincing evidence, regardless of its form. And fifth is the principle of publicity and orality, which you see in Article 183.
We covered publicity in general, but the orality aspect is important here, isn't it?
The orality principle demands that provision must be made for direct oral communication between the parties and the court during the presentation of their cases. This allows for immediate cross-examination, direct testimony, and it prevents the case from becoming purely an exchange of written, passive submissions.
Okay, let's look at the broader context of legal traditions by examining the two archetypal models of fact-finding globally, adversarial and inquisitorial.
Right. The adversarial procedure, which we trace to common law countries, assumes that truth emerges best from a vigorous contest between highly partisan advocates. The lawyer is focused on their client's best interest, adopting a win-at-all-costs mentality, within the rules, of course.
And the judge in that system.
The judge is an impartial and largely passive umpire. They restrict their intervention to ensuring the rules are observed, maintaining order, and delivering a judgment based solely on the evidence and arguments that are presented by the parties. In contrast, you have the inquisitorial procedure, common in civil law countries. This assumes that truth is best discovered through an official, state-led inquiry. The judge is the central, active investigator and truth finder. They lead the search for evidence, they order its production, and they critically examine witnesses. Advocates collaborate with the court rather than combat each other.
So, given that Ethiopia's substantive law, the civil code, is rooted in the civil law tradition, but its procedure is influenced by common law, which mode defines our court proceedings?
The Ethiopian system is a classic mixed model. The source influence is undeniable. The 1965 Civil Procedure Code is widely observed to be influenced by the 1908 Indian Code of Civil Procedure, which is a clear common law product. This gives our CPC an inherently adversarial framework.
But our practice blends this. Where do we see the inquisitorial feature surviving?
We see the blend in the distribution of power. Party autonomy in initiating cases and defining the scope of the dispute is purely adversarial. However, the judicial authority in evidence management and inquiry, where the judge has the power to question witnesses deeply or to manage the production schedule, that leans more inquisitorial. This hybrid system requires sophisticated management, and it's really up to you, the law student, to have your own reasons stand on how best to classify and critique the practical workings of this mixed system.
Let's briefly look back at history, because understanding where the CPC came from explains a lot of its current tensions. Before 1942, there was no uniform, systematically applied procedural law.
That's right. Justice was dispensed informally, often through spontaneous roadside adjudicatory tribunals or through family elders. And this environment bred a notoriously litigious culture, fostering complex, customary adversarial contentions.
Like the Tatayak Muge and the Esitajba, what did those customary contentions actually involve for the average person in a dispute?
These were often complex, formalized challenges. Tatayak Muge literally means something like question and contest. It involved intricate verbal sparring and the ritualized presentation of oral arguments before community elders. Isitajiba was often a form of oath or solemn affirmation meant to prove one's credibility. Success was less about codified law and more about oratory skills, vigor of gesture, and the moral influence of the disputants.
And this relied heavily on the amagaj.
Yes, the amugak, or advocate. These were self-taught men who lacked any formal legal training but possessed extraordinary rhetorical skills. They were masters of customary law, capable of influencing the outcome of a case through persuasive oratory and sheer force of personality. It serves as proof that procedural skill has always been crucial in Ethiopian justice.
And the historical appellate ladder shows just how decentralized and individualized justice really was. It was a long, sequential climb.
The structure was vertical and extensive. Appeals could start at a village tribunal, move up to the Chikasham courts, then to the Eshalika courts, through the governor courts, up to the Woomba raises, and eventually reaching the highest regular court, the Afanagas.
But the ultimate authority was still the emperor.
Correct. The final step was the Zufan Chilo, the Imperial Majesty's Chilo. The emperor presided, and his decision was absolutely final. Crucially, the emperor was not bound by formal laws. His legitimacy was derived from the sovereign prerogative and the conception of the king as the ultimate source of justice.
And this history is still visible in the code today.
It is. While the practice is obsolete, its historical existence is recognized in the CPC under Article 322 regarding appeal to the emperor and Articles 361-370 concerning review by the emperor's court. These are provisions that reflect that past structure.
The move towards modernity really began with the Administration of Justice Proclamation number 21942.
That was the foundational step. It established the first modern court structure, and critically, it attempted to streamline the process by limiting appeals to only one level. This was followed by the first written procedural law, the Court Procedure Rules Legal Notice Number 331943, which was highly influenced by Indian laws and covered both civil and criminal procedure.
This all leads us to the watershed moment. The current Civil Procedural Code, issued as Decree Number 52 of 1965.
And the circumstances of its promulgation are important. It was issued as a decree by the emperor under Article 92 of the revised constitution because Parliament was not in session. This bypassed the typical legislative review, which is a key factor in one of the code's enduring problems, interpretation.
Let's focus on the debate over the source. Some have argued the borrowing was selective, but the consensus seems to be otherwise.
The overwhelming scholarly consensus holds that the majority of the provisions were verbatim copies of the 1908 Indian Civil Procedure Code. The Indian Code is therefore the primary material source of our current Civil Procedure Code.
Now, let's deep dive into the four major problems created by the features and origins of the 1965 Code. First, the conflict over forms and conciseness.
This is a massive source of practical contention. The code is relatively concise, 483 articles, plus the schedules of forms. The conflict stems from blatant inconsistencies between the English and the Amharic versions. For example, Article 82 of the Amharic text makes the use of the schedule forms for pleadings indispensably mandatory.
But the English version is less rigid, and then there's an internal contradiction in the Amharic version itself.
Exactly. The same Amharic version contains Article 244, which stipulates that the court cannot allow a preliminary objection based solely on the non-observance of formal requirements.
So one article demands strict adherence to form, and another says failure to adhere can't be a reason for dismissal.
Right. This fiercely conflicting prescription plagues the court system.
The second problem relates to the blatant mismatches between versions.
Since the English was the master text, many inconsistencies are attributed to Amharic mistranslations. Law students and practitioners are often advised that in situations of deadlock or contradiction, it's more profitable to consult the English version and, as possible, the original 1908 Indian Code to infer the original legislative intent, although that runs into the next problem,
which is the fundamental conflict between traditions, civil law, substantive rules crashing head-on into common law procedural rules.
This creates severe conceptual and terminological deadlocks. The codes simply use different languages, and they presuppose different legal environments. It can be insurmountably difficult to relate specific procedural requirements from the Indian or common law tradition to their precise parallels in our civil law substantive framework.
And what's the advice when that happens?
When this leads to defeating the law's purpose, the suggestion from the source is clear. Prefer reference to common law materials for interpretation, since that is the tradition the CPC sprung from.
The fourth problem relates to interpretation itself. Since the code was a decree, there's an absence of travaux préparatoire. Let's define that for the listener.
Travaux preparatoires are the preparatory works, the legislative documents, committee reports, and parliamentary debates that record the drafter's intent and the policy rationale behind the law. Since the 1965 Code was a decree, these documents just don't exist.
Which severely limits the most reliable method of statutory interpretation, trying to infer the intention of the drafters.
It does.
So if we can't look at intent, what mode of interpretation must be used instead?
We're forced to use more practice-oriented and teleological mode of interpretation. Judges have to look at the general purpose of the procedural rules, justice, speed, and efficiency, to resolve ambiguities rather than trying to divine an unrecorded legislative intent.
And finally, the Code's features include a lack of necessary regulations and then some subsequent amendments.
The Code empowered the Ministry of Justice to issue regulations, but until 1975, virtually none were issued. We must, however, note the key subsequent amendments. Proc. No. 511975 drastically reduced the number of appeals to only one, which reflected a push for finality. And Proc. No. 841975 amended Article 311 to restrict applications for a change of venue, ensuring they could only be brought before the hearing of evidence had started. The court structure has also seen multiple legal updates culminating in the current structure we have today. Yes, we can trace the lineage through repealed federal courts proclamations, like 259996 and 1389098, to the current comprehensive law, the Federal Courts Proclamation No. 1234/2013. This governs the establishment of the federal courts alongside the Federal High Court Establishment Proclamation No. 32222 Citizen 3, which defines the jurisdiction of the High Court.
So to bring this foundational deep dive to a close, let's give our audience the full picture. For a third-year law student, where does one look to find the authoritative rules of civil procedure in Ethiopia today? It's clearly a multi-layered system.
It is essential to consult this entire hierarchy of sources. Firstly, the ultimate foundation is the FDRE Constitution, which provides the overriding due process guarantees, like the right to a fair trial and judicial independence.
Secondly, the bedrock text, the Civil Procedure Code of Ethiopia from 1965, which provides the bulk of the rules.
Thirdly, the different proclamations and substantive codes, such as the Federal Courts Proclamation 12342/013, and those procedural rules that are hidden inside the Civil Code, like the limitation articles we discussed.
Fourthly, the directives of the Federal Supreme Court. These are operational instructions that guide lower courts on case management and process.
Fifthly, and crucially, the precedent decisions of the FSC. These decisions, particularly those from the cassation bench, play a vital role in interpreting, clarifying, and unifying the application of the law across all federal and regional courts. They're absolutely essential for understanding the law in motion.
And finally, the practical instruments used by the judiciary itself, the court's official bench books and manuals. Mastery requires synthesizing all 6 of these layers.
So we've established that civil procedure is not a dry secondary subject. It's the crucial living mechanism of justice. We've examined its teleological purpose, we've navigated the historical influences of the mixed common law and civil law traditions, and we've addressed the profound challenges that plague its modern implementation, from inconsistent judgment policies to the conflict between the English and Amharic texts. Mastering CP requires more than just memorizing articles. It requires a critical understanding of these foundational principles.
Absolutely. The goal is to ensure the rules serve justice, not destroy it through over-application. For you, the learner, as you reflect on this first part of our series, I want you to continually mull over that central conflict we discussed, the tension between the strict rule of law and the spirit of justice. How would you have resolved the infamous 8-year succession case retrial? If the court had an undeniable fundamental jurisdictional defect, was the defeat of the law's spirit in validating 8 years of effort justifiable to uphold the constitutional rule that courts must be established and organized strictly by law? It's a profound question that shapes judicial responsibility and defines the ethics of procedural practice in Ethiopia. That brings us to the end of our foundational deep dive. Thank you for joining us for this crucial first step into Ethiopian civil procedure. We look forward to continuing this comprehensive series with you next time.